This morning.
All rise. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated.
In just a moment, the court will call the afternoon docket. I want to say thank you for being here today. We are traveling under the authority of the legislature to hold oral argument in any county in which that is in our district. That it includes Walker County. We have to sit in the county seat of the county. I can't go out to Riverside or Trinidad and hold oral arguments out there. It's got to be in the city limits of the city of Huntsville. And you think, well, that's, you know, why would you have it anywhere else? Well, there's another institution in Steve's home county of Brazos that we can't hold oral argument at the city of College Station because it is not the county seat. So when we go to hold oral arguments over there, Blinn is our host, and we have it out at the now most recently at the Relish campus out kind of on the edge of Bryan. And so we have to have the oral argument in the city limits. So I did a much longer introduction this morning to the assembled students. If you are interested in kind of how this came about and why we're here, you can go to YouTube and look for the court's YouTube channel and see the full discussion. I'm going to forego that this afternoon in the interest of time. And the one thing I will mention, or two things that we do differently when we do this for educational purposes on a college campus. There's two things that we do differently. You see Mike walking around with a camera. We do not allow that when we are in the Waco courtroom. You can do that here as long as you don't do flash. The other thing that we do here in this environment is that we allow the attorneys to turn to the audience and make a 3-minute presentation to you to put their case in context so that you can then understand the arguments that they are going to make to us in their time for oral argument. The one thing I would like to say that I did not get to mention this morning is that the LEAP students who are over here work with Mike Yawn to put this on, and they are essentially our host. And we appreciate it very much that you all take your time to do this. And I know that Mike richly rewards you with something. I don't know what it is, but accolades or references when you go to do a job. But I have met Mike's former LEAP students in Austin at the Texas legislature where they work. So whatever it is that he does, it is effective in helping you all find careers and jobs later. So your time is well spent here. So Mike, thank you for what you do. We do have a Huntsville Independent School District board member with us this afternoon. Ken, help me with your last name. I left my cheat sheet in the back. Holland. Ken Holland, good to have you. Thank you very much. And with that, I'm going to call the afternoon docket. If I find my docket sheet. Matt's going, you would think after doing this 25 years, he would be more prepared, but here's where we are. By the way, for the audience, I think everybody else in the room probably knows, to my right is Matt Johnson, Justice on the Court, and Steve Smith is on my left. He's the oldest judge, but he's not the senior judge. So, and that's not an age-related comment. At this time, the court calls Wright versus Jones. Are the parties ready, and are there any preliminary matters? Joe Rivera, Tyler Talbot. Thank you, counsel. Mr. Rivera, you may proceed with your 3 minutes when you are ready. You can do it from your table, or you can stand over next to the lectern.
The county landlord. Give you something. When we come up. With all that.
Actually, he's going to take his 3 minutes right before he goes. And so you're up for 17 minutes.
Oh, okay.
Yes, sir.
Please report.
Hang on just a second. Let me get the time reset. I know you don't want to start with 3 minutes. There you go. You may proceed when ready, counsel.
Oh, you never know. 3 minutes. Hey, please report. Your Honor, we're here today on a deed dispute that you, I think, know that this was our dispute from our briefs. So I'll just jump right in. There is a deed that is the heart of this case. And if you don't have a copy of that, I'm not going to draw extra copies, but this one you can have it handy. Because I think that.
Got mine?
Got mine?
Everybody's got one. Proceed.
Then as I described in my 3 minute word, I represent Lewis Wright. Lewis Wright is the son of Billy Wright, Billy and his wife, Jean Wright, executed the deed that you have in front of that deed. Named Billy Wright is the grantor, named Lewis Wright is the grantee, describes the property, and describes the reservation. As we stand here today, before any revocation by anyone, Billy Wright has died. And so with our argument that the life estate reserved to Billy, by Billy as the grantor, he died. And that Lewis Wright has the remaining. That's Billy what happened. That's called by the language of the deed, and that's what's called by very straightforward and simple application of well-established Texas law.
Counsel, is there anything in the record other than the general conduct of the parties that tells us whether or not this is community property?
No, I don't think so. I think as far as the any sort of evidence about when this was prior or not, I did not see anything in the record. And I think everyone has ignored it.
Do you view this as it says it's a joint deed. Do you agree with the appellee's characterization that Jean Wright was also a grantor under this deed?
Yes, I think at the time this document was executed, you were the grantor of her 1/2 interest, Billy Wright was the grantor of his 1/2 interest, and each one of them reserved for themselves in their 1/2 interest rights. That is the reading of this deed.
So what was granted was what? By each individual or together?
Well, I think the 6 and 1/2. And here's why. Let's assume for the sake of argument, this is in fact community property. But we all know that each of the spouses own a 1/2 undivided interest in community property. And so whether we say it's a joint grant of the overall parcel or it's a grant of my 1/2 and your 1/2, the effect is the same. I can't grant it to anyone else your 1/2. You can't grant it to anyone else my 1/2. So we want to put this deed on its face and constitute, which is a transfer to Lewis Wright of the fee for this parcel of land in this house. We have to do it jointly. Now, what each of us might do to make a reservation, that grant of my 1/2 versus your 1/2, separate. But as a basic principle, I would certainly from that I have the authority to grant person. That's part of that. Get off the bridge. Out of trouble with all. Certainly, we have a reservation, but Gene cannot reserve the ability to provoke or dispose of Billy's one half interest in his property. And forgive me if I use first name, but if I say right, we're all wrong. But that's the basic proposition. And I think that's supported by any number of canons of construction that this board and the Supreme Court recognizes.
So is it your position and that the remainder interest was passed at the time of signing the deed, subject to the language that might pull back a reservation? Are you saying that remainder interest went and it just resided in Billy, excuse me, the son, Lewis, thank you, in Lewis, and then upon Billy's passing, that it became fully operational?
That's correct. That's property 101. That's, Professor Featherston 101, as far as that's how life is. My remainder vests in me immediately upon someone creating a life estate for which I am the remainder. Now, whether the conditions to vest the full fee ever, including the death of the brand, triggering a brand reservation, that's a separate issue. But the remainder itself is an immediate interest in the property at the time of the grant.
What is the effect of the attempted revocation?
Billy brought on it, nothing.
So is your position that right now, as we sit here today, these people each own half of this property?
I don't want to have it. I don't have it. The stepmother, Gina.
Why is Lewis's half, assuming that we agree with you on that step, why is Lewis's half not subject to a homestead right in by Miss Wright, Jean Wright?
Well, I don't think it's not. Let me take that in two steps. I think as an addition, it could be woodland. But the constitutional homestead right, Part 16, Section 52 of the Constitution, says that you get that homestead right so for so long as you are using it as your home, you reside. And the record evidence is she's no longer residing, hasn't since 2019, because she's in another. And so if she were to say, prior to that date, I lived here, this homestead, Lewis, I don't know one half interest, but I have the exclusive right to use it to possess this property. That's a different argument.
So what you're saying is that she may have had the right, but it's been abandoned. But the trial court did not make that determination.
Keep in mind, right, I think it's important on our opinion to know that we asked for the final all of it and overdue notice because some of these issues, where are we in terms of findings and finding factors? On record evidence, you no longer living. There's no apparent. It's the fact that when Billy died, Bishop and Gene Wright was still living in the property, she couldn't make a homestead. Keep in mind that the constitutional homestead right is a possessory. It's not an ownership. And there are cases from this court and the Supreme Court says it doesn't transfer ownership because it's lost on surveying. And so once you stop living there, there's no owner. But how do we get to that conclusion that they are in fact doing owners? This, they give a number of canons of construction get us to that result. First, Just the old whack, right? We've all heard Professor Pedersen say whack, that works a partition. So the moment that Billy died, all Jean Wright owned was her 1/2 interest. Billy's 1/2 interest became subject to the law of intestacy or the terms of any will or other instrument to dispose of that 1/2 interest. And Jean simply had no power other than to invoke the homestead right. But as far as disposing of the ownership, she simply had. Secondly, I think that the other provisions, kind of canons of construction will lead to the result that we're asking for. The greatest estate doctrine. I think that the Supreme Court has recognized that doctrine in various cases. Trial versus Dragon, 593 Southwest 30. Supreme Court said that also. The language says, interpretation of the language is consistent with Randy Lewis, Billy 1/2 interest. Or the terms of the will, observe the life of state to himself. On their language says, would you be directly contrary to the greatest estate law? I think as a supplement to that, you have the rule about strictly construing reservations. This court held and Reagan versus Marathon Oil, 50 Southwest 3070. That quote, reservation and a deed is strongly construed against the grand court in favor of the grantee. And so I have no doubt that Mr. Talbot will offer interpretations of the reservation to say that it allows for being to somehow revoke the grant liability even long after his death. And that's what we're. We have a man who at the time he died granted his son state. Months after his death, the surviving wife says, I'm not just revoking against my grant, I'm revoking against the other grant. This court's own interpretation of the restrictions and regulations. We're going to construe it as narrow as possible. And that means they revoke the grant. Finally, you have the rule against implied survivorship. That's what they're arguing for. They say it's a joint grant, it's community property, so certainly Billy must continue that. Right. What we have in the state's code, section 112.051, is the recognition that we can have a right of survivorship in community property. And what you have in section 112.052 is how you accomplish it. Subsection B says this is the language to be used when you want that right of survivorship. It says with right of survivorship will become the property of survivor. Will this then and belong to the surviving spouse, shall pass to the surviving spouse. You can read the 3 pages in front of you. So we all make it back to the way it is. Get that right.
Now, is the 112, 051, 052, is that related to transfer on death deeds, or is that a different provision under the estates code?
Well, there are provisions that speak to transfer on death deeds, but those provisions that address transfer on death deed would address the life estate, and they do it. You spirit in my mind the trigger of transferring we call now the relationship. State issue.
Okay, so that's a survivorship statute, not a transfer on death deed statute.
Correct.
Okay.
And it was designed, and that statute was passed to avoid this very issue of, well, the context and what you all might consider, or what I might consider the right thing to do. We read into the legislature says this is how you do what King Wright says happened. And it did not happen. That language was not in this. And in fact, The legislation went further in subsection D and says you cannot infer a right of survivorship merely because of the asset. And that's all we have here. We have none of the language that creates right of survivorship. And the only thing that even remotely implies that is operates the state, restriction on reservations, and no implied survivorship creates the framework that this court is to interpret this deed. This and the starting point for us is the four corners document itself. Again, it is a remarkable thing to think that. I mean, when a man passed away, he had created a life estate, created a remainder interest in a son, and months after he passes away, surviving spouse can say, no longer content with this grant. And not just as to me and my own half, but as to my late brother. And this court has analyzed this sort of language. This court itself has analyzed this sort of language that would accomplish that one. Cases like Stover versus Sykes, 5.7 Southwest 2nd, 229. This court he was long, so somewhat here, but it says it is our will and our desire that the survivor of us, as the case may be, shall have the rights and authority below given and have all of these things included, with the survivor having no restriction whatsoever as to the disposition of any property, and that upon the death of such survivor, all of the remaining estate shall go to our children. And so the court, this court, said that that language was effective on the death of the to transfer all the estate of the wife, and that the children's claims to the following estate were then conditioned on surviving the wife. Nothing even remotely similar to that sort of language. I'm like now, I think the practice. Context influence. I think what's wrong with this decision, because if you look at the record, I believe it's around page 49, 50. After the motion to enter judgment, I never intended to divest Billy of her Lewis his interest in the property. And the trumper actually goes through and strikes a lot of the language of post judgment. But what remains is a ruling that Gene Wright owns this 100% fee simple. And there is simply nothing in the record, nothing that supports the idea that she is the 100%. This deed is not good. There's no will to control it. And we keep in mind, if this deed is not good, and Billy Wright dies in that state, his one half will go away to justice.
Well, I think counsel is going to argue, because he did in his brief, that there was a, Billy had a will and it left everything to Gene. And does that even enter into the analysis that we need to make?
No, because we only get there if this court agrees.
Yes, please.
We only get there if this court agrees that after Billy is done, Gene Wright can revoke Billy's grant and thereby throw his one half interest back into its state and thereby have that. Putting in the details.
Quick question on procedure. You made reference to it both in your brief and again at oral arguments, but it is not briefed as an issue separately. The trial court's failure to file findings of fact and conclusions of law. Assuming that the request was made timely, the reminder was made timely, can we deal with that if there is not an issue in the brief?
Well, I would ask the court to look at our property if that's relevant. Because my belief is to ask the finding of fact, including on the idea that this court is free because it's a matter of law to reinterpret the deed. It's not bound by the trial court interpretation. And this court could go one of a handful of ways. It's not ambiguous in our favor, it's not ambiguous in their favor, or is it? My concern is that if you look at the trial court's record as far as testimony, there is very little, if any, evidence about him as far as testimony, if we assume ambiguity. And so I don't know exactly what fine I'm thinking of this thing. The trial court, because the trial court says the revocation is effective, and it's just the revocation is effective, she can round over 100%, she therefore has sold the interest. Well, is that because the deed is ambiguous? And you believe it? Think something. Think it is. This court. The ability to know.
Thank you, counsel. You'll have 5 minutes for rebuttal.
Good afternoon, everyone. My name is Howard Taylor. This case is my labor. Now, if that comes as a surprise to you, you forget it. I listened to that people all minutes, and Mr. Rivera was very careful. Huge problem. It allows people to give a piece of property while at the same time reserving the right to use it or even revoke it. And it's unique in Texas law. So as you heard, the specific issue in this case is this. The husband and wife, 20 years. When those people like create dicks, purely, let me temper to the actual human talking about this case is going to affect them. As you heard, Billy and Gene White in the home tenant and not in 2015, he was worried. He worried about his home. He was out. And so they signed it. Both of them. Now, why they did that? The law wants to go back to the intent. And you remember, yeah, but here's what is going on. There are two different things. The first is this. You put this in the inspection. He says it's they find a that falls. And exactly as they do in true 5 weeks after signing the waiver, we have Lewis was not the caretaker. So we can call him getting money. The penalties were both, I guess, past Lewis can be. If it can come on the property, she's close, and what makes it secure? The issue in this case is simply this. Was the revocation effective? If so, then Gene and the police have the right to use the property and she and her husband did this. And the answer is yes. There was nothing in the text of the waiver deed. There's nothing in the text of the opinion her to exercise the rights she and her husband did. So I mean, now here we're asking the court to affirm that was. May it please the court, I am told on behalf of this court should affirm the revocation was the power to revoke is tethered to the life estate periods of both grantors, meaning that those rights exist so long as one of the grantors sponsors exist.
Where is that grant?
Sarah,
Where's the grant of the life estate to each other?
the life estate grant is in that second. They're joint grantors. They both reserve and exit. And after we the analysis,
But how do you reserve something that you cannot grant?
So I think this is getting to the nub of what you heard from Ellen. This suggestion that these are just kind of two products coming together. They have no right to grant, if I'm following the question, but it's that this was not a meeting of two halves where they just mutually agreed to do the same. Here's why I mean that. Chief Justice Gray, and I'm going to probably put a pan of rounds. I'm going to do so. This isn't two people, each of the half of the pie going, here's what I'm going to do with my half of the pie. Here's what you're going to do with your half of the pie. Oh, wow, you just so happen to be doing the same thing. It's right down. They both jointly own the whole pie. They both said, here is what we as joint grantors, husband and wife, are going to do in our homestead. We are going to jointly grant, but jointly reserve.
But what did they have to grant?
The deed to the property to Lewis.
Now let's stick with your example. What did they have to grant? A pie.
The whole pie.
But neither can grant the whole pie. They don't have a whole pie. They only each have half a pie. It just happens to be half of each molecule of the pie.
Well, maybe we're in gastronomical territory. They both together, they collectively own the whole pie. I don't think that's in dispute.
Do you agree that it's community property?
That's not in dispute.
You agree with that then?
I do agree.
Okay.
This is community. And really the challenge of this analysis that I think we can and should is twofold. First, who were the grantors? That being how we define the relevant right to state period. And second, what rights did they reserve? And so I want to walk through that.
Don't we need to first decide what they granted?
Yes, and I apologize if I'm not following your question. It's my understanding that they granted jointly in a labor deed for Lewis to have the property subject to the rights of use and the rights of occupation. So it was in effect a deed with a reservation of a life estate and the right to a vote, just like a general warranty deed with a reservation of a life estate, but with the labor kind of care. And I'm going to do that in kind of two brief strokes. And first of all, factually and legally, the applicant did have. And the second is I want to actually take up and address Lewis's suggestion that his interpretations actually is not as text. As to the first of those, I think that is borne on the record in the law in both ways. First of which is that the life estate period of both grantors. The second is that.
All right, I want to make sure I understand. Well, go through your four and then I'll circle back.
The second is simply that you've got time and time again this intentional mistreatment of the record of who the grantors were, what they conveyed, what they reserved, what the rights were. Make sure we're very clear, because I think when we get the law straight, the facts straight, that the likelihood of third is the significance of the expenses. The fourth is finally, even if this court says, hey, this isn't a model 30, there's ample evidence of the party's intent that this was precisely the intent. And so I'm going to jump to where I think your question was, Chief Justice Gray, and I understand to me that legal analysis. And I think Mr. Rivera and I can safely say there's no Texas case.
Isn't that what keeps this from being unique to Texas law? Because in fact, the concept of a ladybird deed is across all 50 states, and it hasn't been widely used. And I have not found in my research any other purportedly joint ladybird deed. The whole concept of conveying, doing a ladybird deed, if it is one grantor, one grantee, works real well for what the briefs argue is the purpose of this. But isn't the problem here, because we do have two grantors and they are granting their rights, but they've got to be doing it separately. It's in one document. And I analogize this deed somewhat to the joint wills that were once more common in Texas until the legislature got involved. That there's still two wills. They happen to be on the same piece of paper, but it is still two wills. And this is like that in that, yes, it's a joint deed, it's on document, but there's still two deeds here.
And I would respectfully push back against that.
Please do.
That's something that my wife. Jointly on that property again. Even if my wife and I were to get a piece of property reserved for life estate, we don't simultaneously execute the same document. We do it together, right? There's no reason then why a labor deed is any different. It is a conveyance. To someone else. That seems to be painful. Why I'm suggesting that both ranchers continue to hold those rights is for two reasons, both of which I don't think are disputed on the Constitution. First of which is you can have more than one life estate holder. There can be 2, 3, 4 life estate holders. The second of which is the reserved period of the life estate does not end until the death of the life estate. What that means then functionally is if you reserve certain rights to use the sell, that those rights continue to exist until the expiration of.
But where is the grant of the second, what I would characterize as the second, where is the grant of a life estate to Gene Wright?
Rantors jointly, and so let's go ahead and jump in.
No, let's stick with where is the grant of a life estate to Gene of Billy's right in under the deed?
It was a joint conveyance to Lewis in which both rantors reserved the life estate. Billy reserved the life estate.
But that's a grant to Lewis. I'm looking for the grant of a life estate to the other spouse.
They did not grant life estates to one another. They reserved.
Why didn't they? Because that fixes what a Lady Bird deed, a joint would that would seem to me to be what fixes the problem with this deed.
Well, and again, in the analogous circumstance, you have a grant of a deed to someone and a reservation of life estates. It's not the grantors exchanging life estates. It's a reservation unto themselves.
Unto themselves.
Unto themselves collectively and jointly.
Well, but not collectively and jointly because you can't reserve what you didn't grant.
Can't reserve what you didn't grant. Dispute that. They did not grant Lewis the right to come and occupy. They didn't grant Lewis the right to have a say when they sold it. They didn't grant Lewis the right to have ultimate Trump and veto power whether they could vote. They kept that to themselves. They did not.
Actually, it's irrelevant, but they probably did grant to Lewis the right to sell it. Just nobody would, in their right mind, would buy it because it could get revoked while Billy and Lewis were alive. But that's
Well,
I'm focused on this concept of grant, reservations, but there wasn't anything that I have seen that I can find where there's that grant of a life estate to the other spouse during their lifetime or an assignment of the right to revoke if they could after Billy died. And that's a whole nother issue, but.
And I may be able to clear that up a little bit.
Please.
What I think the point is that one spouse passes away and there's no gift or reservation of a life estate before it goes to Lewis, to the other spouse, to the other undivided 50% holder of the property. And so that's where I think Judge Gray's question goes, is that once, if there's no reservation, one to each spouse, then if one spouse dies, it looks like the remainder interest becomes a full interest in that spouse's undivided 1/2% or undivided 1/2 interest.
I'll kind of tether in the pie analogy in that these are not two halves. Before you measure, they collectively measured it by their joint line. They said that in effect, essentially, last year, whether or not required to then also grant each other. I've seen no suggestion of the appellates. I've seen nothing in the law requiring them to effectively reserve a joint life estate. There has to be a joint life estate.
Well, there has to be a grant of a life estate.
A reservation.
No, there has to be a grant first. If you're going to have a reservation of a life estate that can be exercised during the life of the one that lives longer, you've got to give the one that lives longer a life estate.
In the whole.
In the whole, yes.
Counting the deceased spouse to undivided.
She was an owner. She had a built-in life estate. We know constitutionally.
She had a built-in life estate to her portion of the property she owned.
Correct.
But did she have life estate in that portion which she did not own without having the conveyance by her husband? Isn't that what we're talking about?
Yeah, that's what I'm trying, that's where I'm trying to wrap my mind around it.
Sure, and I see where we got to hit the wall here. My submission report recently. Joint conveyors, the jointly owned mind, they reserve those rights. And I understand.
Okay.
What is problematic, notably though, is that I think both sides said, hey, this really could have been, there could have been an express reservation, an express point, could have done this. And I'm stuck though, with the time and circumstances. They were worried about Gene, they were worried about the home. 5 weeks after.
If they're worried about the home, why didn't they just leave the will alone? I mean, because, if without this document, they don't have a problem. They probate Billy's will, she has the property, we're done.
Well, and what I understand is sometimes people want to do this because they believe that builds additional protection to the survivor spouse. It's beneficial in this way. But the question remains that Lewis's suggestion is this document evinces an intent for me to always have the file. If that's true, why would they expressly carve out the right not to give it to him? Reading it in the way that Lewis suggested defeats the very purpose of it. They could have executed the transfer on death deed. They could have executed a warranty for the right of the life estate. When you consider the surrounding circumstances of it and why they did it, there's no reason other than to protect Gene.
Well, let me ask this question. You talk about there was evidence at the trial court about what kind of person Lewis is, what kind of person. Do we even get to any of that in construing this deed? If it's clear here, doesn't that all go to parole evidence?
Two answers there, Justice Smith, and one comes. And here's what they say. They say, even if a contract is ambiguous, a court may still consider the surrounding facts and circumstances in aid of construction of the contract. And so I say this to make 2 points. First, you could construe this document as unambiguous and use the timeline and circumstances to effectuate a result. If, and to your question, Justice Smith, it is ambiguous, then there does need, then you can consider all sorts.
Clearly.
And, you know, personal power, findings of fact and conclusions of law, and got 2 problems there. First of which wasn't teed up as an issue on appeal. I generally ask, when I don't get the findings I want, I say, please abate, send all the different. I request that as a term of review in this court. And the second is, and I know this because the court told me this 2 years ago, is you only get there if you've been prevented from actually presenting your appeal, right? There's no dispute about exactly what's the issue. Is the revocation effective? And it's either effective, and that's either based on the plain language, the trial court said, no, or it's based on the surrounding facts and circumstances. I don't know what abating and sending it back to the trial court would do to aid or assist the court's. The last thing I kind of want to touch on in the last minute here, and so I'll get back to it, is this notion of a life estate. Jean holds a life estate. That is that means that she's entitled to exclusive possession of operation. That means that she is the sole person here. We know that Lewis was on. He was trespassing. Damages were awarded. The question is, if the grantor is expressly reserved the right to sell without joining the Lewis, without any liability to him, what rights does she have? It's less than a life estate probably reserved for themselves. And the reason I pointed out the problems constitutionally under 52 is because from 2015 to 2019, Lewis's claims is that his right vested immediately. Cannot be true.
You're talking about just the homestead right that she had.
Correct, which was in existence for at least. You see, I'm running out of time here. It's for these reasons. What else?
I want to ask one more question, at least, even though Matt may have to bail me out again. Who owned the interest between the time of Billy's death and her purported revocation?
She did.
She who? She who? There's a lot of. Under what theory?
What a labor deed creates is a vested remainder subject to total rights.
But Lewis had the contingent benefit during that time.
Subject to total rights.
But as to what did Jean, in other words, why does Jean have okay, Lewis, you're saying Lewis still had it all until his stepsister revoked it.
I'm saying, in wording here is a little weird, I'm curious. According to a vested remainder subject to total divestment. If it was never revoked, he got the property, free and clear. If it was revoked, he got it. Not only, and revocation is not the issue, he could have sold the property. For the express terms of what the grantor was going to do. So yes, from 15 to 19, and we are years to pay. Gene and I more.
Okay. Anything else? Anything else? Thank you, Council. You may proceed.
With the idea of Lewis right. Laws not on your side, dirty. But that gun kicks as hard as it shoots, because as your honors have pointed out, why have a deed if it will accomplishes everything that they say? Why have a power of attorney if G might already owns? The fact of the matter is, if Billy died, it's equally likely that he believed he had provided for his son. He would have a hard time accumulating assets, having a place to live. And the idea that this was some sort of estate planning measure by GMI is completely unsupported by the record, because you only get into Medicare except when your state is at a certain size. And as your honor pointed out, the deed in light of the will is superfluous. The language of the deed, however, is not superfluous, because as your honor pointed out in the questioning, number one, this deed can be read in context of all the things that I pointed out, including the constitutional life estate. Billy may well have granted this deed or his attorney with the idea that Jean would be provided for during the course of her life with a life estate in his 1/2 interest, which again is possessory only, not an ownership interest. And that is why you will not find the converse or the joint states that your honor spent so much time questioning. And that language, I think it's, well, number one, I think it's pretty remarkable that when you ask, where's the grant? It's in the reservation. Where's the left? It's in the right. And the reservation, that language is not, because it could be read to, again, Gene can sell, do whatever she wants. Go to the building. And I like to remind you to think about the bigger context. If any time two join enter into the we're compromising the spot. That they have some sort of rights out amongst themselves to think of the test. What if two business owners enter into some sort of transaction? They're flipping, they buy a piece of property that's joint owned, and they want to sell it. One of them backs out. And I know now they'll strike a sweetheart deal with the one that still wants to go through with it because, hey, we're joint owned. Once you sign up, we're joint owned. Really have. Think of it this way. Could Gene have revoked as the building one have interest during his life? The death makes no difference then. That's okay. Got a life estate defined as not only her one half interest for her life, but also in Billy's one half interest. She could have decided this is a bad idea the day after this deed was filed. Said no, hope it all. But that's not how. That's not how you do property. Even though it is a single asset, and we have to join in together as spouses to dispose of it all, we still, just like joint owners, just like each own one half of the property. Maybe up the bottom. Stated on his face. Vested, that vested. He wants to do with her one half, that's a separate issue.
Well, I think that goes back to my first question was, doesn't the remainder interest vest at the time that the deed is signed? Okay, and you're talking about a full vestment of all the rights, all the property rights in the bundle. Okay, and I'm not picking on that. But it's a little different in this case than it would be if it was, of course it is, than if it was just a straight life estate situation. Does that remainder interest truly vest at the time the document's signed if both people who signed the document retain an interest to revoke it? Basically a vesting and a divesting, is that what occurs in this situation? If they decide to execute the revocation?
I'm going to come down to a second.
That time. That's it.
Absolutely.
The simple answer to your question is yes. The longer answer to your question is that part of why I hesitate to refer to this as a lien for deed is just Greg pointed out. We use that phrase and we use it in all 50 states, but there is no statutory definition, there's no case law definition, and so these concepts of, well, we're going to provide for your spouse, or the idea that that's all implicit in a lien for deed is just not common. What is absolutely true about it is that the next question. Be simple statement. We don't have to, which no one else in the entire world really right time, full fee interest, by a portion of that property. That's what we have to do. Position, I think, for some about what the effect of that. That he has one half interest. So our position is we have to be trial court, and
I've got to ask one more question now. So this is how one leads to another. It's like eating potato chips. Right there at the end, you said he couldn't be a trespasser. But if she has a homestead interest, can she not exclude him?
Well, so again, short answer, yes, longer answer, and you heard the testimony of the trial court that the intent was he would live with her and take care of her. And so he was a permissive resident. Instead of something, he started misbehaving. Well, number one, I believe that the record evidence is that he is allegedly misbehaving after she is in the nursing home, and that's how he's got free to misbehave. But number two, that evidence about whether or not he misbehaved, again, is irrelevant to the question before the court, which is what would the intent on this document stop?
Well, that gets back to the I'm thinking now about the trespass question of whether or not he could be a trespasser if during the period of the homestead, he was asked to leave. And so, maybe that's too far afield from where we are, out.
I think the short answer, yes, he could. But the question is, did she ever tell him, get the heck out, you're not welcome?
Okay. We're good. Thank you very much. This case is submitted. You all are excused. The court is adjourned. Mike, you did want to open it up for questions still? Anyone in the audience, including the LEAP, we'll even take questions from counsel. We may not answer them, particularly if they have anything to do with the cases that were argued today. Yeah, go back and let's watch the YouTube for the 10 o'clock this morning, and you'll see that my answer to that. So, well, exactly, because, and this may be of interest to you all. We don't announce the decision today. This is an appellate court, as you've heard. These cases have already been tried. To get to an effective appeal, you have to argue that the trial court committed an error and that error impacted the trial court's judgment. That's when you get the right to appeal, or that's what the issue on the appeal is. And if you don't have that, you're not going to get to an appeal. That's where we are. These are already in a judgment in the trial court, and they've got to convince us that there is an error in that judgment that can be corrected. And so we're going to go back and study the law. You heard them both cite a lot of cases, and we're going to look at those cases and the language in those cases and make a decision. We'll write an opinion. In the pamphlets that were handed out is a way you can sign up for case mail, and you can follow what happens in this case or any other case at any court in the state of Texas. And when you sign up for case mail, what it literally does is anytime a document is filed in that case management system, you get notified with an email. You can then go online to the case management system, see what that document was. It could be anything from a post-submission brief, which if these gentlemen cited any cases in their arguments that are not included in their briefs, they're supposed to follow up with a brief by Friday, citing those cases and providing those citations to us. Or it could be an opinion. It could be a motion for rehearing. A lot of things could happen. We may issue our opinion and neither one of them agree with it, or one of them disagrees with it for certain. And they take it to the next court, which in this case would be the Texas Supreme Court. And anything that gets filed, you'll get an email. And that's the way to track what happens in these cases. So I strongly encourage you to do it just so you'll see the steps until the opinion gets issued and then what can happen after the opinion. So I bet these lawyers are already signed up for case mail on every case that they are involved in, which probably means a lot for Tyler on appeal. So questions? Yes, sir. Do you want my answer or you want their answer or their answer? Well, I'm gonna, actually, Tyler made a statement about that, and I'm gonna let Tyler answer it first, and then if I disagree with his answer, then I'll give you an answer.
They are not unique offenses. They are one of the things. You might use one just to.
And a lot of times they're used so Medicaid won't come in and try to take your house if you're in a nursing home. You can tell Medicare, we really don't have any interest in this house, even though it looks like, and technically we do, but it's not worth coming to get.
Yes, Hope.
You know, the court, I suppose, ones, if we left questions remaining on the briefing, that's not one. So, I think we can find that number of cases. And these two just.
Have brief, will travel.
And it's actually much simpler than that. I failed to note that the same attorney was on 2 cases. We normally try to avoid that, and it's just the recommendations for the arguments and the cases to be argued and the discussion. We just didn't notice that he was on 2 cases. So, you had another question, Hope?
I'd say probably less than Joe, I'd say 30 to 40, but the ebbs and flows, you may spend nothing but looking at the numbers, 2 weeks ago, 2 weeks ago. It just kind of peaks and valleys. I'm curious to what's talking.
If you had asked me, let's see, right now our docket is running at less than 200. We're about 170 cases pending on our docket right now. And it's probably, I'm trying to remember, it's the lowest that it has been in my 25 years on the court. So.
Is there a particular reason?
Well, and that's, and even with the 100 and, well, I can't. Yeah. The COVID definitely had an impact on the number of cases that we are seeing. It's where y'all sort of understand there's 80 judges in the state of Texas that do what we do. There are 14 courts of appeals. The fewest number of judges on any court is 3. You are looking at the entire Waco Court of Appeals, the 3 judges that are here. The 2 Houston courts, for example, they both have 9 judges on those. Dallas has 13. And so everything we do at there's a group of the 14 of us that is called the Council of Chief Justices. And everything we do, we convert it to average cases per judge. So at the peak, during my tenure at the court, we were getting 145 case dispositions per year. That's so 145 cases per judge disposed out the door. We were having about 170 cases filed. And so that meant we were transferring cases out. We are now down to about 100 and somewhere between 5 and 10 cases per judge filed in Waco, or excuse me, statewide. But our number in Waco is still about 150. So we're still transferring out about 100 cases, or one judge's load of work to other courts of appeals that are below the statewide average. The part of the problem in that, and the reason for it is we had historically been what we call underfiled. We were under the statewide average. We readjusted the districts just a little bit. That's in 2005 when we picked up Walker County. We also picked up Burleson County. And then in 2003, the session before that, we had picked up all of Brazos County, where Steve's from, because previously Brazos County could go to either us or the Houston court. The filings at that point for about 4 years were just right. Not too many, not, just right. As, what is it? 3 bears? Goldilocks. Yeah, I knew it was something about bears. So anyway, it was just right. And then about 2007, our filings just soared, and statewide filings didn't rise nearly as quickly as we did. Much of it is population driven. We've got some huge population growth areas. Bryan College Station, Huntsville has actually been quite active, but then we've got Ellis County on the north end of the district, which is Ennis and Waxahachie, and then the Cleburne Burleson area, which is Johnson County. And so with the growth of those areas, we just wound up, we're way high on our population, we're way higher on our filings, and so we have to transfer out a lot of cases. And I forget if that answered your question. Okay. That is the problem when you ask me a question. So I'll try to limit it to, did we get your question answered? Okay. Anybody else? Mike?
This year, just we've got at least 5 pre-level students here. You've got to get all pre-level students. It can be like, don't do it.
I always say the exact same thing. I said, call an attorney, has to talk to him, because a number of things are true. 1, attorneys like to talk. 2, they'll usually buy you lunch. 3, you can figure out if you like what they do or they don't. Just have a miserable. The more experience you get, the more attorneys, good or bad, the more kind of. Yeah. Part of it is we need to decide on the experience.
Anybody else? All right, we will wrap it up here, and y'all have a safe trip back to Waco. And thank y'all for hosting us. Mike, thank you.
have a lot of students go to law school and you talk to another, you guys have gone to law school and then you can say, okay, we're gonna do it here. And the other law school students are really going to continue here, so they can get time for them.
They didn't have much choice. I will suggest though, to all of the law students or the undergraduates that are looking at it, is to be sure and get Tyler's card before he leaves, since he just invited you all to lunch.
Ask him to go to George's.